Welcome back. Now, the Electoral Act 2026 marks a digital revolution for Nigeria's 2027 polls. That's what some will say, and replaces the 2022 Act. But legal experts are concerned and are being cautious of potential conflicts that might come up between the Act and the Constitution. And as you know, anything that is contrary to the ground norm, which is the Constitution, is thrown out. But let's say this. Let's look at the key strengths of the 2026 Electoral Act. Now, the 2026 Electoral Act, there were upgrades that were brought in there and with enough strengths. Technical, tech-driven transparency mandates the early funding to boost transparency and planning. Meanwhile, new criminal penalties for officials now deter or are supposed to deter procedural abuse to ensure strict electoral integrity. Inclusive identification, rules out, and elimination of indirect primaries empower grassroots voters. Well, these reforms target elite capture, fostering a more accessible and representative democratic process for 2027. But let's look at some things that might be a weakness in this law. The discretionary manual backups and restricted judicial review create significant loopholes. Critics warn that network issue gaps and filing limits may facilitate manipulation while unconstitutionally blocking citizens from seeking justice. Punitive petitioner fines and mandated primary formats threaten party autonomy and legal access. Furthermore, compressed election schedules risk favoring wealthy incumbents by undermining the engagement of less resourced political actors. I mean, because of the time frame now, it might be difficult for people to raise the money they need to contest any position that they are seeking. But let's look at they're the strength and they're the weakness. What about issues that might arise as it concerns the Constitution of Nigeria as amended? So see this. Mandating specific primary methods may violate Section 40's protection of party autonomy. Such interference risks unconstitutional meddling, overstepping the National Assembly's legislative boundaries, and infringing upon political associations' internal affairs. You know that part of the Constitution that talks about freedom of association and all of that. Okay. High filing fees and narrow petition grounds create illegal barriers to justice. What? But there is that right of every citizen, the right to judicial, to justice. Well, I'm trying to put it together. I'm not a legal man, but we'll get a lawyer to look at this. Now, these punitive measures stifle free speech and contradict the fundamental constitutional right to seek redress or electoral grievances. Okay. I'm being joined by Vincent Ottaokpukpu, constitutional lawyer, public affairs analyst in the studio. Thank you for joining us, Vincent.
Thank you for having me.
Also joining us from our newsroom, is Michael Amosun. I don't know if he's there right now, a legal practitioner as well. Oh, there you are, Michael. Nice to see you. Welcome.
Nice to meet you again.
Okay, let me start with you, Vincent. I mean, we've looked at the things we've looked at so far. You've seen the strengths of the 2026 Electoral Act. You've seen the weaknesses, and I'm sure you've seen this before now. You've also seen the possible conflicts with the Constitution. And what do you think overall, generally?
For purposes of clarity and sincere appreciation of the subject matter, we must start by re-emphasizing that the Constitution is a diagram norm. Thank you for emphasizing that. And it provides by Section 1 that this Constitution is supreme, and its provisions shall have a binding force at all persons and authority throughout the Federal Republic of Nigeria. So, and the sub 1, subsection 3, that if any law is inconsistent with the provision of this Constitution, such other law shall, to the extent of its inconsistency, be void, including the Electoral Act. Because Constitution is diagram norm, from which every other legal norm derives its legal validity and their effect. Constitution will not contain everything to guide human conduct and human affairs. That's where there is now delegated power on the National Assembly to make the miniature laws, which the Electoral Act falls onto. Now, by the provisions of the Constitution, there are so many, the new Electoral Act has brought so many innovations. And there are also certain shortcomings that seems to violate the principles of the principles in the 1999 Constitution. Now, I will tell you for sure that the 2026 Electoral Act signed into law by the president seems to be that the National Assembly has taken us back in the age of 2010 Electoral Act. Because some of the innovations brought by the 2022 Electoral Act, they have been removed.
Okay.
Now, one, when you look at Section 77 of the Constitution of the Electoral Act, new Electoral Act, which has provoked a certain scholarship disputation, ranging from contentious issues and responses, such that the section provides that a political party shall maintain a digital voters register, register of members with the commission. That is okay. Now, he provided also that the such register must be submitted to INEC 21 days to their primary election. But the problem there is that a member of a political party who happens to register today and who wants to contest the election to vote and to be voted for cannot be eligible to contest unless his or her name is contained on the list of membership register already submitted to INEC. That is to say, if the list is submitted today to INEC, register of voters to INEC today, and peradventure by next tomorrow I choose to belong to a political party, they will say, no, you can't be a member of a political party.
Which is that not curing some situations that when we have people jumping from one party to the other and trying to contest for position?
No, what I'm saying that you cannot effectively implement that section vis-a-vis the provision of section 40 of the Constitution, which has granted right to freedom of assembly and association.
No, but hold on.
Let me come. The provisions of the Constitution is highest.
I agree.
But
hold on. No, Vincent, hold on. You cannot just jump us like that.
Okay,
hold on.
Okay.
The Constitution is highest. It's the grandum.
Yes.
All right?
Yes.
But then the Constitution also allows the parties to come up with their own internal party constitutions.
Yes.
And all of these party constitutions have it that you must have been a member for a while before you want to contest for any position on the platform of the party.
Yes.
So I guess what the new Electoral Act is trying to do is to deter those who want to jump from party A to party B because they lost a ticket here. They are sure they can get on this. But hold on. Let's go to Michael Amosun. Michael, we'd like you to weigh in on this one here now. He is concerned that this section might also hinder those who are seeking freedom of expression and seeking to contest for one position or the other. What do you think?
My opinion is going to be a bit different from my learning friend in the studio there. I think that particularly what that section has done is to try and curb cross-carpeting across party lines. I think it's not healthy enough for our democracy. It's not healthy enough. Why we do not contest that there's the freedom of association? A 21-day window to have all digital registers available is not a bad thing. I think that we can hold ourselves accountable to some extent by allowing every person interested to run to be a member 21 days to whatever is happening. I don't know what can happen between 21 days to the election. Really, I don't think and if it does infringe on that section of the Constitution, the court will be there to, matters will be contested in court. Constitutional matter, of course, like he said, is going to take precedence over every other matter that comes under it.
But since you have brought in the court here, let's look at this matter of the punitive measures. You know, when you have punitive measures that hinder or do not allow people room to contest a situation in court, the time limit, and then that matter of at what point are you allowed to file, the time limit for filing of any situation, how would that work?
Election petition matters from the beginning for every one of us that knows, has always come with its own stringent timelines. It is why it's in a class of its own. The timeline for election petition matter is not same as every other matter, you know. So, but like I said, when laws are being passed like this, it is left to be tested in the courts. Some of them is going to be returned, some of them is going to be retained. So we will look forward to the coming days to see, you know, how that plays out ordinarily.
You say some are going to be returned, some are going to be retained. I don't understand.
For me, the purposes of emphasis, this issue of Section 77, to me, the Supreme Court have held in litany and copy of cases that the Electoral Act, the party constitution, cannot impose further obligation and qualification criteria on candidates for election unless those specified under the Constitution. Section 65 has provided qualification for the House of Reps and Senate. Section 106, I think so, or 109. 106 has provided for State Assembly, 131 for President, and 177 for governorship. 1, you must be a citizen of Nigeria. 2, you must belong to a political party and sponsored by the political party. 3, you must attain the age of 35 years, and as case may be, you must also have a school certificate or its equivalent. These are laconically and copiously provided as ground to contest election under those sections. And Supreme Court have emphasized it time without number. There's no other miniature law, including Electoral Act or party constitution and guideline, that can impose further obligation. So by making enacting that section 77 and saying that you must be a member of a political party from so and so, is imposing a further obligation on a political party outside the criteria for membership.
What happened to what happened to the Supreme Court ruling that the party's internal affairs, this matter of membership and leadership, is the party's internal affairs?
I am coming to that. That's
There's no time. You need to get to the point quick.
That support my position.
How?
That because the Electoral Act, as it were, has not defined what is internal affairs. So it will say recourse to judicial pronouncement to determine what is internal affairs.
Okay, can you just hold your thoughts for a moment there? We'll go on a quick break, and when we'll come back, this conversation will pick it up again. Just stay with us.